Hello, everyone. Welcome back to another IFAS AI and Data Science seminar. Our speaker today is Nick Pfeifer. He's a double-gator. He earned both his undergraduate degree in aerospace engineering and his JD with a certificate in intellectual property from UF. For over 12 years, Nick has been practicing intellectual property law with a focus on patent and trademark matters across a variety of industries, including aerospace, mechanical systems, medical devices, software, artificial intelligence. He regularly advises clients on protecting and enforcing their innovation in highly technical fields. And in addition to his legal practice, Nick also serves on the board of advisors for Deep Media, an AI startup where he's providing guidance on IP strategy in this rapidly evolving field of artificial intelligence. So please welcome Nick Pfeifer.
Thank you all. Happy to be here. As you heard, I am a double gator, so this university holds a special place in my heart. So thank you for having me. All right. So. Here we go. All right. So as you know, we're here to discuss intellectual property and artificial intelligence. Second, lost my PowerPoint. So, we're going without PowerPoint. Here's just kind of a session roadmap on what I want to discuss today. I want to kind of give an initial intro to AI and innovation to kind of help set the stage. Then we're going to go into an overview of the different types of intellectual property. After that, we'll go into some specifics of intellectual property in relation to AI. And then I want to go over some protection strategies and best practices for you all as researchers. And then finally, we'll do a Q&A at the end. Hopefully, you guys can still be awake by then. All right, so why are we even talking about intellectual property? The primary reason is that AI is accelerating across industry, and intellectual property just hasn't kept up. It's a bit of a gray area. The courts are still addressing what is protectable, and we don't have any laws on the books yet. So we're still in a little bit of a period of transition here. But it's important for us to try to provide some clarity to researchers, universities, institutions. So hopefully this will provide you with a little bit of clarity. All right, so what exactly is intellectual property? These are essentially legal rights that are granted for creations of AI. There's different types. We have patents, which are going to protect your innovations and provide you with exclusive rights to those. We have trademarks, which are going to protect your brands. Copyrights are going to protect your creative works and the distribution of those. And then we have trade secrets, which are intended to protect your confidential business information. All right, so let's dig a little bit deeper into a patent. So a patent is, again, a government-granted exclusive right to your invention. It gives you the right to make, use, sell, and import your claimed invention. There's different types. We have utility patents, which are going to protect anything with function. We have plant patents, which are going to protect new varieties of plants. Then we have design patents that are going to protect the new and original ornamental designs. So these are non-functional aspects. The duration is going to be a little bit different depending on the type of patent. So utility and plant patents, those are going to get 20 years, and then design patents are going to get 15 years. And there's a little bit of variation depending on examination and whether or not there are different term disclaimers in this. But you can actually see there on the right side of the screen, this is the first page of a patent that was granted to the University of Florida. It's actually for a harvesting system that uses machine vision. So I don't know if those particular vendors are here or listening online, but I thought that was a fun example of a patent for you all to look at.
Nathan Boyd and Arnold Schumann, right?
Yep.
Yep. So that's their easy AI startup.
Oh, is it really?
Yeah.
Yeah. Great example.
Good example.
All right, so let's look at trademarks then. A trademark is really anything that can be used to identify and distinguish products and services. It can be a logo, a brand name, a slogan. It can even be a color. UPS has a trademark on that particular brown. And then it can be songs and tunes. NBC has a trademark on their introductory tune, I guess, that you hear when they start the program. Ultimately, the purpose of a trademark is to protect brand identity, but also prevent consumer confusion. So it's kind of a two-pronged purpose there. Your rights are going to provide you with the exclusive right to whatever your trademark is and similar variants of that, used in connection with similar or the same goods and services. And the duration of the trademark is theoretically indefinite, so long as you are using that mark and you pay your government royalties. So it is an important part of intellectual property. And then if you look here on the right side of the screen, I'm sure you guys all recognize this mark. This is the IFAS mark, but that is the Federal Trademark Registration for IFAS.
So we only got around to doing that in 2015? It looks like.
Yes. Probably should have done it sooner. It looks like first used 1964, so we waited quite a bit for that. All right, here we have copyrights. Copyrights are again intended to protect your original work of authorship, and that's once it's fixed in tangible form. So you can think of maybe authorship as playing a song. Well, if you're just playing it out loud, it's not fixed, right? It's here and it's gone. But if you record it, now it's fixed in tangible form. And once that happens, you have an inherent copyright in that particular work. Some other examples of copyrights, particularly with respect to AI, we can look at images that are generated, AI data, films, and your software code. Now there's a caveat there. There has to be some sort of human input in order to secure copyright protection, because you cannot be an author unless you're a human. That's what courts have decided. So make sure that you're keeping track of the human input when you're using AI to produce it. The rights that are afforded through copyright, the exclusive right to reproduce, distribute, publicly display, and create adaptations of your creative work. And there's an interesting duration there for copyright. It's the life of the author plus 70 years. It might sound like a weird time frame that ultimately came about due to Mickey Mouse and the court case revolving around that. So that is the duration. The other thing to mention with copyrights is that it is inherent upon fixing it in tangible form, and once you record it, once you write it down, whatever, that copyright is inherent. But if you register with the federal government, you get a little bit of additional rights, and those are mostly tied to enforcement. So with a copyright, if you wanted to enforce your copyright because someone was legally reproducing it, if you don't have a copyright registration with the federal government, then you have to prove that you have lost profits or you receive damages. If you have a registration, then you can go to the court and say, I want statutory damages. The court says, okay, here's what the value of that is, and for each time they've infringed upon it, you get that amount of money. So there's actually a huge benefit to filing your copyright registrations. It's pretty inexpensive when it comes to the government fee. It gets you quite a lot when it comes to enforcement. And then I have over here, this is actually an image that I pirated from the UF website. Not copyright infringement, because this is just a lecture. But I thought it was interesting. You actually can't see it right now. It is.
It's probably on the desktop. Use the desktop mouse.
See it. Okay, so I thought this one was interesting because we have a copyright in the image itself, but then if you actually look at the top left corner, we also have a trademark on top of that image. So you can see that this is one way to layer our intellectual property. And we'll get into that layering a little bit further. Alright, so trade secrets. This is really any information that has a business advantage and is kept confidential. Some examples that you probably know Coca-Cola recipe or formula, the KFC recipe, Google search algorithm. The interesting features with trade secrets is that there's no registration required. We're not submitting anything. Rather, we're just keeping it protected. And as long as we're able to keep it under some sort of lock and key, whether that's physical or digital, we can maintain that copy or that trade secret, and you maintain the rights associated with that. As a really interesting example, Coca-Cola has an actual vault in Atlanta where they keep the recipe. So that's not really necessary, you don't need a full vault, but you do want to have certain protections in place with respect to like non-disclosure agreements and confidentiality agreements, and then keep the knowledge to it, only the core people that need to know. And the rights that are afforded with that are really just related to enforcement against theft. There's not really an ability to say, hey, they reverse engineered my trade secret. It's really just to protect against theft. I didn't have an example of trade secrets before, so don't deal with that image. Okay, so here's kind of a hot topic right now. AI as a tool versus AI as a creator. Obviously the tool, we're just assisting humans. As a creator, we're generating inventions, we're generating art, whatever it may be, the AI system is generating something. So who owns the outputs? Well, we've had 2 court cases, right, as of now. There's no statutes on the books that establish what happens with AI generated output. However, the cases considered whether or not AI, without any human intervention, could own copyright. The court said no. Authorship requires humans. The other case is, again, an AI system that produced an invention. And the guy who created the model that produced it said, I did nothing, it did it all on its own. So there's no human input. And in that situation, the court said again, AI cannot sub out for a human. It is not an inventor. So there has to be some amount of human contribution, whether it's copyright or patent. We don't know where that line is right now, because we only have those 2 cases that dealt with strictly no human interaction, and we don't have any laws on the books. So right now, for you all, it's important to record what you're doing when it comes to AI generated outputs. Write down how you contributed in any sort of way, and hopefully that will be enough if it's ever changed. Okay, so now I want to get into where artificial intelligence meets intellectual property. This is just kind of going to be an overview, and we'll dive a little bit deeper. But for patents, we're looking for inventions, whether it be processes or new models, whatever it may be. We're looking for technological advancements. Copyrights, we're looking at creative works, code, media, data, things of that nature. Trademarks, is probably the easiest one. We're just looking for brands. How do you identify your particular brand? One important thing to keep in mind is don't use merely generic or merely descriptive or generic terms. You probably don't know this, but GPT, ChatGPT, they're trying to trademark GPT. GPT is considered an acronym for a merely descriptive set of terms. And so the court said you can't have it. So before you brand your AI tool, think about these things. Because if you look at the other side, Grok, it's an arbitrary term for AI that is deemed registrable. So definitely things to keep in mind. And then trade secrets. We want to look at our data, our training sets, our algorithms, things that are not going to be easily reverse engineered and are not available for the public to look at. So maybe your code, they can see your code if it's downloaded onto their computer or whatever. But in a trade secret, we don't want to include that type of information. Everything that's kept confidential is what we're looking for. So now let's dig deeper into patents. This is probably the most complex and the most interesting intellectual property that we have for AI. So again, human inventorship, it is required. The other thing that's required is patentable subject matter. And I'll explain that a little bit more on a some subsequent slides, but essentially the patentable subject matter analysis is a consideration of, is this an abstract idea? Are we simply using AI to do X? Or is it a practical application? And what practical application means is a little bit nuanced, but essentially we're looking for improvements to solutions, or solutions to problems, things of that nature. How is it intrinsically tied into technology? The other requirement is novelty. This one's pretty easy, it just hasn't been done before. Is it new, or has someone else done it? If it's never been done before, then you meet this novelty requirement. And then the last one is non-obviousness. This one is a little bit more complicated. It's a subjective analysis, but essentially the idea is these routine, obvious changes are not considered an invention. Versus unique changes, unexpected results, solutions to particular problems, those are deemed patentable. So that's often a hurdle that we run into with our arguments. Alright, so now let's look at patentable subject matter. This is, again, one of the more important aspects when it comes to patentability. This is something that if you talk to people in your field, they probably say, software is not patentable, AI is not patentable. You've probably heard that a ton. And that stems from this patentable subject matter analysis. But essentially, where we are right now is that applying a generic AI or ML to a new data environment, that is not patentable subject matter. That's what they deemed an abstract idea. We're simply using this generic AI to do something that we were already doing. That's not an invention. It's like similar to using a computer to act as a calculator, right? That's not an invention, it's something that's already been done. Instead, what we want to look for are novel data structures or transformations of data. So examples, maybe a pre-processing technique that converts imaging data into a format that makes the model converge faster. That would be deemed a novel data structure or transformation. We also have technical model modifications. So how are we altering the existing architectures to handle maybe irregular time series data in crop prediction or something else for that matter. We also want to look at potentially improvements to the functioning of a computer or the AI system itself, or even any other technical device. So are we reducing training? Are we reducing the inference computing? Do we have faster execution on edge devices, improving stability, any sort of improvement that we can think of, that's what we want to focus on. And then we have another option is integration into a technical system. So rather than just, we're using AI to predict something or using AI to analyze something, instead we are coupling the AI to a robotic harvesting device, and maybe it's adjusting blade speed in real time to lead to greater yields. So we're tying the AI to the system, and that makes it happen. And then the other thing that we potentially look at is demonstrable technical benefits. So not just we have an improvement, although sometimes that works, but when we can say, hey, we did this research, we did a study, and we found that we're getting 40% improvement on reduction of false positives, so medical imaging or whatever. So those are types of approaches that we can use to avoid a patentable subject matter rejection. And that's something that we want to identify at the onset, because a lot of this revolves around framing the application appropriately to address this potential rejection in the future. So it's important to keep track of, sometimes as researchers you're running into a problem, you solve it right away and you don't think about it again. But that solution might be a commercial advantage that is patentable. So think about that as you're working in your fields. Here's novelty. Again, this one's pretty easy. When it comes to AI, you do have a lot of instances where the same models are being used over and over again. That is not going to be a novelty threshold, but we can focus on the improvements, the unique training techniques, specialized data processing methods, or innovative models. How are we changing the structure? Things of that nature. That's what we're looking to. It's never been done before. We figured it out. Here's the solution. so now we have non-obviousness. Again, this is another one of those challenging requirements. AI is fast moving, and that can work in both directions, right? It might make an examiner say, well, you know, this seems like a very incremental change, and so I think it would have been obvious, but at the same time, this is so new, no one's ever tried that, so maybe it's not obvious. It kind of comes down to a subjective analysis of an examiner, because that's ultimately what they get to do. Obviousness, the way the examination works is the examiner says, I'm going to pretend I have knowledge of everything that's ever existed prior to the filing of your application. And that is any country, any language, anything that's ever been publicly displayed. And then they go and they look at your application, and let's say you're claiming, you know, an invention that has features A, B, and C. Well, if the examiner can find 3 references, and each of them has, one has A, one has B, one has C, the examiner can say, well, it would have been obvious to merge all these together. And here's at least a reasonable basis for doing that. If the examiner can come to that conclusion, now they say your invention is not, or now they say your invention is obvious and not patentable. So when we're dealing with that sort of analysis, we do want to look at what problems are we solving. Maybe we look at the prior art references and say, well, yeah, that has A and this has B, but they couldn't work together for this reason. It just doesn't make sense. So there's ways to combat it, but ultimately, we want to focus our patent applications on those improvements and where the prior art fell short. That will help us get past this, this obviousness threshold. So some points to emphasize there. Unexpected improvements. Those are always good because how is it obvious if it has an unexpected result? And for AI, we're looking at accuracy, efficiency, costs, etc. And then potentially even new or very old problems. If it's a new problem, how is it obvious to solve it? You're the one who found the problem, right? Nobody else would have known about that. If it's an old problem, then we say, yes, it existed forever. No one's ever been able to solve it. We solved it, so therefore it's not obvious. Otherwise it would have been solved before. So a lot of things to think about, but again, as researchers, you want to be focused on what problems that I run into, how did I solve them? And then if you know about things that exist and you know about approaches that failed, it's also helpful to include those and say, hey, look, this stuff failed for this reason. We went this route, and that's what made it work. Okay, so now let's talk about patent harvesting. Because again, as researchers, you're not necessarily thinking about patents all the time. This isn't your primary focus necessarily, but it's important to have in the back of your mind because if you're able to secure IP, you can secure funding, potentially spin out a new company. You know, I'm sure it helps for tenure and all of that. But some things that we want to look to, look for technical improvements. I feel like I'm harping on this improvement thing a lot, but it really is a critical aspect when it comes to patents. So again, we're not just using AI to do X, but we solved this problem, we found this bottleneck, and we were able to overcome it doing this. Again, here's some more examples to think about while you are doing your work. You know, have you come up with new models and structures? That's potentially patentable. Or modifications to improve the accuracy, the stability, the interpretability, scalability, whatever it may be. Those improvements are potentially patentable. Maybe even look at training innovations. You know, the models weren't able to have, you know, X level of success because the training just wasn't there. Now you've improved that training approach, potentially patentable. You know, you can think about cleaning, labeling, augmenting training data. All that stuff might be patentable. Optimizing different routines. Techniques to reduce energy consumption. That's all potentially patentable. And then, you know, think about things like defenses against attacks on AI, or even maybe in the future AI attacks on us, right? Or methods to verify the authenticity of the outputs. All these things are potentially patentable aspects to what you're doing. All right, let's transition to copyright now and how it pertains to artificial intelligence. Again, human authorship is required. I've harped on that a few times now. But here's some examples for you to keep an eye on. training data that you create? Are you curating particular data sets? Are there annotations, labeling guides, or taxonomies? How are you altering the data in a unique way? You potentially secure copyrights on that, and that might have value because maybe your model or other models require specific labeling of training data in order to achieve certain results. And so if you can have the right to that, that could be a huge advantage for you. Prompts, I think this one's pretty obvious, but writing your own scripts and prompts, that's your own creative expression, and you can potentially have copyright in those. And those might have certain value to what you're doing. We can potentially modify the outputs on the back end. Maybe the model is good at doing X, but you have to put in Y in order to get to that next step. And so your input on those could potentially be secured, registerable from a copyright standpoint. We have also the arrangement and organization of outputs or data, all of that, there's potentially copyright there. And then of course your code, your research papers, this kind of more standard stuff, things that you probably already do, but those things are potentially protected under copyrights. And then of course we have when AI outputs something and then you transform it in some sort of way. So again, maybe the AI is making an image, but you ultimately need to modify that image in some sort of way. So that could potentially be something that you secure copyright protection to. All right, now we go to trademarks. I think this one's pretty easy. We kind of touched on it already. Essentially, what sort of branding tools are you using for your AI models, your systems? AI can actually generate the mark or the logos, and then you can secure the rights to that through trademarks due to your intent or your use in connection with the offering of goods or services. So it's not like copyrights and patents where you have to come up with the brand. You can rely on AI-generated branding. It is helpful to potentially prevent others from misappropriating your brand. Again, if we go back to that GPT model, if you look at the trademark website right now and you see how many people have applied for something GPT or GPT something, it is wild. So the fact that they weren't able to secure rights to GPT now prevents them from stopping other people from using similar names that create this association with GPT or OpenAI. The inverse would be true for Grok. Nobody's going to be able to use real estate Grok or something like that, right? Because Grok is going to have exclusive, or I guess Tesla, whoever owns Grok is going to have the exclusive rights to it. And so nobody else is going to be able to come in and start using that because it's going to create confusion in the marketplace. So definitely something to consider when you are thinking about what do we want to call this model or system or device. All right, trade secrets in AI. Again, this is going to be revolving around what sort of information is not going to be publicly accessible or easily reverse engineered. And I think with AI, that comes down to data sets, training methods, and potentially your algorithms. Maybe you can wait to those algorithms if it ultimately winds up being said, although I don't think that's usually the case with AI. But keep in mind that you want to limit exposure of this confidential information. Don't tell everyone about it. Don't publicly disclose it. Keep it confidential, and then you can secure these trade secret rights indefinitely. All right, so here's kind of like a decision framework when you're working through what exactly you should be looking at based on your research or your work. If we're looking at an invention, a technical solution, a device, something like that, we want to look at it from the patent standpoint. And actually, let me back up. I should say all of these can be layered too, and I'll explain that in a little bit, but when we're thinking about them individually, we can also think about them as a combined approach. Okay, so if we're talking about like your creative work, anything that has your artistic expression on it, then we're going to think about it from a copyright standpoint. If it's a brand, trademarks, that was pretty easy. And then confidential information, again, look at it from a trade secret perspective. Now the way all of these can kind of be layered. If we look back to that UF patent on that harvesting device with the machine vision, that is a device that uses AI. They were able to secure patent protection on it. Let's say, for example, there already existed something like that, and ultimately UF required that the system cut an apple from a tree. Like, that was a requirement. So the claim is a little bit narrow. You don't have a ton of protection from the patent standpoint on that. So now we can look at other things, like is there an opportunity to copyright potentially the code that dictates how the machine works? You know, that could potentially provide another layer of protection. And then we can look at, you know, of course, the brand. Maybe it's the IFAS harvester or whatever. We can protect that brand, so somebody has to have a different brand name for the competing device. And then potentially there are some trade secrets that are involved in that particular machine. You know, how do we train the machine vision? Maybe you required a certain data set that allowed the machine to operate with a certain level of efficiency that someone else can't achieve through their data set. So you can layer different types of protection depending on the technology, as long as you're thinking about it proactively as you're going along in your inventory. So here are some best practices from an important consideration: document your human interaction, right? We've gone over how copyrights and patents require human interaction. So let's make sure that we're documenting that. The other thing that's really important, and you may know this, you may not, there are certain publication restrictions that relate to patent law. So in the US, you can publish your paper, your invention, and you can still file a patent within 12 months. There are a lot of countries where you cannot do that. If you publish first, you are barred from seeking patent rights in that country. And that can have a major implication depending on what you're planning on doing with it. Maybe it's a new plant variety and you want to ensure that people in Europe have to pay you to make that plant. Well, if you publish it before you file a patent application, you eliminate that opportunity. So it's very important that you consider whether or not you're going to seek foreign rights, or potentially whether or not you're looking for an exit strategy with a company that operates in these foreign countries, because they want foreign patent rights. So keep all that in mind. Talk to UF Innovate before you publish, and look to see if there's anything that you should be filing in advance of that. We kind of talked about this on the last slide, but consider layering protection. You know, it's one thing for someone to say, well, you know, maybe it's copyrightable, I don't know if we can get a patent on it, you're not even thinking about trade secrets, who cares about the brand, but all of that stuff comes together. If you ultimately want to spin something out or license it, having all those things in place improves your chance of doing that, and it greatly increases the value of that package of intellectual property. These are all things that you want to think about as you're developing and going down this path, so that you can ultimately maximize the return on your investment. And then the last thing is be very careful with your open source. I know a lot of models are open source, it's already programmed, plug and play, right? Let's just use that. The problem is there are licenses attached to these, and they can dictate what you can and cannot do with your innovations on top of the code that you take. So be very careful, if at all possible, do not use it. If you have to use it, let's make sure that we look at those licenses and figure out how can we protect what you're doing, and see if there is another avenue to maybe segment your innovations from what you took. So those are the best practices. The future of AI and IP. They're still evolving. We don't have a set legal framework yet. I'm sure there's going to be some court cases coming down. I doubt the legislature is going to do anything. They typically don't want to get too involved in this type of stuff. We saw it with software in 2014. There hasn't been anything since then. It was a court case. It wasn't the legislature trying to fix anything. There's been talks about it. Don't rely on it. We just kind of have to approach it as these cases come down and do what we think makes the most sense. The other thing is that countries, they deviate on what's potentially patentable subject matter and what is not, especially when it comes to AI. especially when it comes to the amount of human involvement to secure rights to it. So it's very important that we look at those from a country by country basis and see how are they evolving. And that's something where, maybe there's outside counsel in the US, but they have to consult with foreign counsel because they can't practice law in Europe, right? So a lot of considerations, but it's something that, again, we want to keep an eye on and potentially be proactive about. And then of course there's the policy debates of balancing innovation with that disclosure. We love open source because we're giving away our inventions, we're allowing people to innovate off of it, but at the same time, well, if you give it away, you can't monetize it, you can't reap any rewards to all of your time investment. So it's going to be interesting to see what ultimately happens, but and so we'll have to see how this all plays out. So here are just my key takeaways. AI is challenging the traditional intellectual property. We're in a state of flux. Be proactive, do what you can now. Really ensure that you're framing your innovations in a way that gives us the maximum chance of securing intellectual property. Again, it requires a flexible approach. We want to do the layering whenever possible. That will maximize your protection. And then I encourage you as innovators and the university to get involved and help kind of shape these policies if they ever come about. But it's important that we voice our concerns because ultimately you guys are the ones who know AI better than the legislature and the courts. So your involvement is going to potentially have a big impact. So now I want to open it up to your questions. Looks like we finished a little quicker than anticipated, but hopefully that'll give us plenty of time to answer any questions.
Thank you. Great talk. We have time for some questions, which I'm sure people have.
Yeah, I have a question about the examiners. Are they federal employees? Are they on furlough today? How does all that affect the throughput that you predict going through the patent office? And I mean, you get to choose them, or are they randomly assigned? How does that all work?
Yeah, so they are government employees through the Department of Commerce. I want to say there's between 8,000 and 10,000 right now. They used to be all in DC, but they could work remotely. I think they're getting called back. But there are different hubs around the country now. You do not get to choose them. They are randomly assigned, which is tough because, like all humans, they differ in their level of reasonableness. There are examiners, the lowest allowance rate I've ever seen, 8%. I had to deal with an examiner with an 8% allowance rate, which is wild. So he's only allowing 8% of the applications that are filed. The national average is like 68 and change, I think. So you can see how that would be incredibly frustrating. So we don't get to choose them. We can go above them at certain stages. They are still involved in some respect, so you never really get away from them. But yeah, there's some really great examiners, and there's some ones who are not. And it's just kind of luck of the draw. Hope that you get a good one. There is the potential to improve your odds. Something called Track 1 examination, which is basically expedited examination. So the typical backlog of the Patent and Trademark Office, when you file an application, it's not going to get looked at for about 18 months. If you go through Track 1, it gets looked at in about 2.5 months. Right now they're averaging, or they're advertising 2.3 months. There's a little bit of variability depending on the argument, but the examiners who participate in that particular program, they tend to be the more experienced and better examiners, the more reasonable, because ultimately that program is intended to secure a issued patent within 12 months of filing. So they want to make sure that there's not a lot of back and forth with a lot of unreasonableness, because they're bad on that program. So that is something to keep in mind. Fortunately, it does require an additional government fee because nothing is for free at the patent office. As a university, I don't know the exact rate of that, but it's probably around do you know you guys are small or micro entities? You are small. So I think it's around $2,000 of additional government fees. It fluctuates. I think it's a little less right now, but they change it every 6 months. The fees. So, as far as the furlough, yeah, I mean it's probably going to affect them, but at the same time, there's a huge backlog anyways. They're working on production counts, so I'm sure that they're going to be working anyways, just because their production dictates how much they make in bonus. So they're like a regular employee where they're trying to churn out work to get a higher pay.
So they're paid on commission?
Not on commission, they get a base salary, but there's depending on your art unit, your level of experience, you are encouraged to examine a certain number of patent applications within a certain amount of time.
I see.
And so if you exceed that by certain percentages, it increases the amount that you get paid. Yeah. So sometimes you get an office action where it's like a single sentence. And they're like, it's rejected. And you're like, what? Like doesn't meet the burden at all.
And there are no do-overs?
Oh yeah, there's do-overs. I mean, it could be indefinite, right? When a patent is examined, ultimately, I'd say 98% of the time, the patent is rejected the first time. It's almost policy. I did a small externship there, and I got to examine, and my supervisor said, reject everything. Do not allow anything. So there was even one case where I was literally like, I can't reject this, and he's like, go back and find a reason. And then after like 3 or 4 times, I'm like, there's no reason to reject this. They finally allowed it to go through, but it's certainly a policy to reject, and I kind of understand the reason, right? Because it's a 20-year monopoly on your technology. They want to make sure that you're entitled to it, but it goes a little bit farther than it should, in my opinion, at least with some examiners. But theoretically, this back and forth, these rejections, it could extend indefinitely.
So would you plant an obvious reason to reject in the first instance so that you can
I do the opposite.
get status?
So here's what I like to do, and I'll explain the reason why. So when I'm filing an application, I want to know exactly what you think is patentable, and then I want to go after that first. And the reason being is that it shows an examiner that I'm reasonable. I'm not trying to go after the home run right out of the get-go. And if the examiner can't find it, they are most likely going to issue an allowance quickly. They're not going to go back and forth and try to find it because they dictated that I'm not going after everything. And now once I'm able to secure one patent, I can file what's called a continuation application. And now I can broaden the claims out, but you do it incrementally, you almost kind of sneak it through. So if you're kind of playing the game the right way, you can really broaden out your claims and get substantially broader rights by going this route. But in the reverse, right, if I say, I want a patent on this technology and it has just 3 features, right, and the examiner's like, come on, I can find these 3 features. Then you go, okay, well, what if I add in this 4th one? And the examiner goes, well, I can find another one that shows that 4th feature. And you go down this rabbit hole of, I'm adding in a feature, but each time I add in a feature, the examiner's already established that the previous features, it would have been obvious to include all of those. But at some point, it's like, I have 10 features in there now, how is it obvious to combine 10 different things to come up with my invention? Whereas if you started with 10 features, they go, it's probably not obvious to combine all these things. So it's kind of a different way of working the problem, but I tend to find more success by going a little bit narrower and then broadening it back out. Because once the examiner sees it, if it's the same title on a continuation application, you go, oh yeah, I remember this one, what did it have like that one feature? Yeah, it has that one feature, they go allowed. So it's a much easier, it's almost like a rubber stamp sometimes. And then ultimately you end up with something substantially greater than what you might have been able to achieve going the super broad route the first time.
It looks like we have a couple of questions online. Good work, thank you. Pfeifer, go ahead.
Yes, thanks a lot, very interesting. Let me ask you a question related, but I think slightly different, and that is about the right of attribution. So in the academic custom, when researchers look for new work, they have to, and they publish it, they have to cite the original sources. Failing to do that could be, if it's unintentional, it's duplication. If it's intentional, it's plagiarism, and there are all kinds of disciplinary actions following that. In the world of today, we have these generative AI products, which ultimately, like the ChatGPT command, prompts and things like that, they are giving us information, but the attribution is lost. So how we in academia live on our reputation, which is how the original work is attributed to us. Are there any action or ideas on how we can ensure that whatever is digested by the large language model can be attributed to the original source, which is what we really work for? Thank you.
That's a tough one. I'd say whatever your AI is generating, modify it. Don't just take it verbatim. Especially when it comes to, text. There's no reason that you can't modify it in certain ways, make it unique to yourself. I know it does a great job at spitting out information. I'm not gonna sit here and say I've never just taken it wholesale and used what it gave me because it does a great job. You have to review it, of course, but I would definitely say we're going to lose sight of where it originated. There's just nothing we can do about that at this stage. And maybe there'll be some innovations in the future that'll help cite to where that stuff came from. But ultimately, modify whatever is being generated, because that kind of gets us over the plagiarism potential, but then also the human input when it comes to copyrights or patents, whatever it may be.
So Nick, is there a duty to inquire about the underlying sources that sort of inform that output? I mean, maybe that's what Ralph was asking.
Okay.
Because using a generative AI algorithm, it's sort of a black box,
Right.
and you lose track of who had contributed the data or the publications that AI is relying on to create the product.
Okay.
So is there a duty to try to peel the onion back and at least try to attribute?
Yeah, I'm not sure. I haven't run into that particular situation. I haven't heard anything in connection with it. I'd say as long as you're acting reasonably, then you're probably going to meet whatever threshold may or may not exist in the future, right? So maybe somebody says you do have to take steps to attribute it, even if it comes from AI. Well, if AI says, hey, I got this from here, and you look at it and you say, okay, well, that kind of makes sense, it's in play, then maybe cite to it in whatever you're writing. But I'm not aware of any particular standards currently. So that will be interesting though, because I'm sure somebody's thinking about it somewhere. So, good question.
Thank you.
There's a related question online about defining human contribution. Because there's always some, at least trivial human input, right? The AI won't do anything yet without any human input. So the question is, where do you make that transition? When do you say, okay, this is enough human input to be considered?
Yeah, unfortunately, we don't know. Like I said, when we look at the court cases, again, there's no laws. So when we look at the actual court cases, it's trying to establish where is that line. The only consideration that the court had in front of it was if there is absolutely no human contribution, can AI be an author? Can AI be an inventor? So that's all the court addressed. We don't know at what stage human interaction is going to be the threshold required for authorship or inventorship. I wish I had an answer for sure right now, but I just don't. I would say, when possible, contribute. Write down as much as you can to support those contributions. And ultimately, if it comes to a point in the future where they say, okay, we're going to look back at everything and see who contributed to what, and whether or not there's authorship or inventorship, then hopefully you'll have that information stored somewhere, and we can go at that. But it's a black box, just like AI. Yes.
Yes, so there are currently some lawsuits from creators who found out that AI companies trained their LLMs using copyrighted material. Would that count as fair use, and would the output from the AI be considered a derivative work? I'm not really sure how they could prove that they lost profits on something like this unless the AI is just outright copying whole texts.
Yeah, that's a great question. Unfortunately, I don't know the answer to it yet. We kind of have to wait for those cases to play out. there's gonna be arguments on both sides. Are gonna say, well, that is for commercial use because you're creating a product and then you're, selling access to that product, or, maybe you're advertising connection with that product, and therefore there's some commercial component to it, and there is copyright infringement, or it's the reverse side of, well, no, we're just using it for training, there's no actual infringement of the copyright. We don't know yet. It will be very interesting to see how that comes down. If I had to guess, I would say they're probably gonna say it's copyright infringement, but then, on the reverse side, how do you enforce that? I mean, think about all the data that's being input into an AI system right now. I mean, I don't even know what they would do with that. There would just be so much potentially copyrightable information that could be considered infringement that I don't know how you would fight it or control it.
I guess there's also a lot we don't know about how they're being trained because that's considered a trade secret.
Yeah, potentially. We don't know what they're doing with it. And maybe they're manipulating it before they're putting it into the system. What exactly are they inputting and how are they doing it? So it's all very interesting. Gonna have to see how it plays out in the courts.
So thanks for this great talk. I've been wondering about your personal opinion on IP being obsolete in this new age with AI, advent of AI and everything else happening.
Yeah.
Do you think it will significantly change and shift the dynamics and everything that we've been doing for like hundreds of years, right?
Yeah. I think there's always going to be a place for intellectual property, and the reason being is that there's just value in it. Oftentimes a company is assessed based on the intellectual property they have. Sometimes entire companies are sold with no products to show for it; they just have intellectual property. So from that standpoint, I don't think that ultimately we'll get to a point where there's no IP. The thresholds for what is protectable, they're certainly going to change, at least from the court standpoint, if not from legislature. I could see in the future AI is now an author or AI is an inventor, because we're getting to a point where it's going to be working on its own. It doesn't need us really. And if you're going to say that, oh, right now, inputting a prompt is enough to be considered an author, I don't know that that really makes sense. Because are you even doing anything? Like if I tell a painter to make me a painting, am I the author? It's a work for hire situation, but I don't know that I'm an author. I think the painter's the author. And in that same context, if I'm telling the AI, hey, make me a painting, I think it's the author, but I might own that copyright to it. So I don't know how they're going to dissect that word authorship, right? We're in a unique time. I think things are going to change. I think there'll always be intellectual property to some extent. There's always going to be value in it. And it's the only real way to ensure that you get value for your investment of your time, your energy, and your mind. So I think it'll always be here, but it's going to be really interesting to see how it changes. Yes.
Yeah, so I have a question. One of the things you suggested was to keep tight control on training data sets.
Mm-hmm.
Don't you lose that control the moment the AI interacts with the training data set?
I'd say you still maintain control of the data itself, because I'm talking about the input data, right?
Yeah.
So you have your input data doesn't need to change. The AI model is going to do whatever it's going to do to that training data. It'll probably output something completely distinct. So you will lose a little bit of control over those outputs. But really, if it's the training data that is ultimately resulting in whatever improvement we're looking for, then keeping that training data as it is prior to input is probably still really valuable. Does that make sense?
These large language models, in UF context, we're pretty restricted in terms of which models we can use because of privacy concerns, confidential information.
Yeah, that's another.
That's a little different from using a training data set, creating your own algorithm.
Right. Yeah, when you're using it for external systems, that definitely gets questionable. You might lose it right there because you just gave it away, right? So it's not confidential anymore, potentially. And you kind of already authorized the use of it, so you kind of give away your copyright rights in it. So yeah, I mean, from the training data standpoint, keeping it your own is easier done when it's your own model, for sure. So that's definitely another interesting wrinkle in the whole situation. Look at someone else's model. How does that play into
So Nick, if faculty had question about any of the work that you do, what's sort of the appropriate time or way to reach out to you? I mean, is it typically, once you've got something you really want to file a patent, or is it farther upstream or even farther downstream of that invention?
Yeah, so when it comes to patents, you're at a point where you can file for a patent where you either conceptually reduce it to practice or physically reduce it to practice. So if you know how it's going to work, if you know the ins and outs, there might be a few missing details here and there, some refinements, but once you know generally how it's going to work, I think that's the right stage. Now, on your own end, you should be keeping track of like those improvements, those solutions or those problems that you ran into, how you got past them, things of that nature. But ultimately, whenever you reach out, we want to be pretty close to the position of we know how it's going to work, and we know what the improvement is, and we know how it's better than whatever it existed before it. And once we know that, then we're in a pretty good spot to say, okay, what makes sense here? Can we patent it? Should we copyright it? Et cetera.
So how do you work in conjunction with the offices of tech licensing at universities? Does that work?
Yeah, so usually most universities have like an invention disclosure form, and it's pretty bare bones. It'll be like a title and then a short write-up, maybe 2 to 5 paragraphs.
Yeah. Ours is online, there's no excuse not to do it, it's very easy, I just want to put that out there.
Yeah, so usually that's enough to start because it's my job to write the patent, right? I just need to know how your technology works. And sometimes it's a phone call, sometimes it's a super detailed write-up like, hey, we're gonna submit this thing next week. So there's a lot of variability there. I would say as long as you know what your invention is and you know what makes it unique, that's enough to start the process. And then it'll be hammering details out from there. I like to get probably too involved. I like to kind of spitball on some ideas and see if you guys have thought about various things. But that's kind of a way for me to help establish the scope of your rights to prevent other people from kind of end-arounding your invention. So, once you get to that stage, I think it makes sense to have a conversation with whoever outside counsel in the sense of that.
So last real brief question, what got you interested in AI as a lawyer?
I don't know. It's such a unique concept, and getting to experience it myself, with hopping on ChatGPT in the early stages, I was just really fascinated with it. And I happened to run into some clients that were working on AI, and it's related to adjusting, the lips on, like if you watch a movie and they translate the language and dub over the audio, the lips never match up. And so they were working on ways to manipulate it and make it work, and just seeing like the behind the details of how they're doing that, it's really exciting to see, where AI can go. And for me, I just immediately started saying like, let's do this for everything. AI can do anything. Where do we stop? So that's kind of what gets me excited about it. It's the new horizon, right? We don't know where it's going to go, but it's very exciting. And I love to see how people are applying it in different ways.
All right. Thank you, Pfeifer again.